Judiciary Committee considering S6 with some additional testimony, and we will start with Detective Drew Coda. If you could identify yourself for the record and proceed and tell us what you think about S6, and I'm sure we'll have some questions for you as well.
Thank you. Good afternoon. My name is Drew Coda. I am a detective sergeant with the State Police out of the St. Johnsbury Barracks. I've been with the State Police coming up on 14 years now. In the last 8.5 or so, I've been assigned to our Bureau of Criminal Investigations. Mainly during that time frame, I've done a lot of investigations with our Special Investigations Unit, the SIUs.
Just one moment. Can you turn it up just a little bit? The volume is. Go ahead, Detective.
Do you want me to repeat anything, or?
No, I think you're good. We heard you, but we just going forward. Thank you very much. Go ahead.
So the bulk of that time in BCI doing the SIU work involving child abuse, child sexual abuse, sexual assault of adults, but mainly children. And then working with other general BCI type investigations, so burglaries, frauds, all the way up to homicide investigations. I've had the opportunity to attend several different types of interview and interrogation classes and courses. I've heard a lot of testimony previous talking about READ. I've gone to READ technique. I've been to the Wicklander Zulawski and Associates course, been to courses about written statements, about body language, and I've been to most recently the peace course that the State Police has put on. Out of all those courses in my time as an investigator, I can say that I never use one of those courses in its entirety, and that I use bits and pieces of those courses throughout my interview with people that their names have come up in investigations, and we are trying to rule them in or rule them out as a suspect. Custodial interrogations are a little bit different. Typically, somebody has been taken into custody because we already have enough information to do so. They're read their Miranda rights. Actually, the room that I'm sitting in right now is one of our interview rooms here at St. Johnsbury. They have the opportunity to leave or to no longer talk to us. And then the goal of that conversation, of that, I would call it an interview, not so much an interrogation, because I don't think we really interrogate people in the way that law enforcement did, 20 plus years ago. A lot of what we see or a lot of what we hear about from TV doesn't happen in Vermont. In doing those conversations, our job is to gather information, to use that information to corroborate our statements that we've gotten from witnesses or any other types of evidence, whether it's physical evidence or digital evidence, what have you. We then use that information that we get from our suspects to establish the validity of the information that we got from our victim. Using something like deception happens. I use it routinely in my interviews with people, and what some people would consider an interrogation. It's a very good tool. It has its place. It's not the end-all be-all when it comes to an interview, but it certainly has become very useful throughout the course of my time in law enforcement. With a lot of these investigations, especially when you talk about child sexual abuse, there is no physical evidence. It's years old. There's only 2 people in the room, what have you. Using something deceptive such as an example, just implanting in somebody's mind the possibility of evidence, asking a question like, is it, if there was a SAIN kit that was obtained from our victim, what are the chances that your DNA will be found on that kit when we send it to the lab? Some people would say that is coercive and deceptive. I would agree it's a deceptive tactic, but at the same time, it's a question. But sometimes questions that simple can be what kind of tips the person over the edge to start talking about what happened. Anytime that we do actually get a confession out of somebody, it has to be vetted. So we don't just stop, take the I did it, and bring that to a prosecutor. We're then going to continue to ask questions if the person is willing to continue the conversation. And we're going to get as much information about the crime that we know has happened from them, so that we can vet that information and make sure that it's a truthful and accurate admission that they were involved in the crime, or they had knowledge of whatever we're investigating. Then we're going to turn that information over to a prosecutor, and the prosecutor has to go through the checks and balances, ensuring that that information is truthful and accurate before they present that to a jury or to a judge, and then ultimately to a jury. If at any point in time there's questions about that information is going to be squashed when it goes to court. Some of the things that I've heard other people talk about are certainly things that happen in other places and have happened over the course of human history. But I would argue that within the last 20 years or so, using techniques of talking to people and using deception that has been vetted by the courts and is well within the bounds of legal accepted practice, I don't think that we're seeing what some places are seeing. Guys, deception is a tool in the toolbox as much as all of these different types of interview courses are tools. Some people use different types of interview techniques as their tool. It's a good guideline, but it's not something that you can always do repeatably every single time with all kinds of different people. Peace is a model that works for some people and definitely does not work for other types of people. You can have a checklist all you want to talk about different crimes with different people, but having a conversation with somebody who maybe just has been through the system a million times, peace is not going to work. You're not going to be able to have a conversation with that type of person. But it all comes down to whether or not that person wants to have the conversation, and they have the right to not to. If this bill is to move forward as it is written, I think it will severely handcuff our ability to interview people and to hold them accountable for the actions that they have made, and to get justice for the victims who these acts are perpetrated against. I think having a sole model policy will set up law enforcement for failure. That's all I have. Thank you.
So I'm sure we have a few questions. I'd just like to start. So you focused on sex crimes. Are those? How about the use of the deceptive statements in other situations? Are they more or less important? Is there something special about particularly child abuse, sex crimes, etc.?
I focus on that in particular because in a lot of other types of crimes, let's say a homicide, there's typically a lot of evidence that's gained throughout the investigation. I'm one of the crime scene search team leaders for the state police. And so, when we go to a crime scene, we're gathering tons and tons of evidence that will be used potentially to bring somebody to justice. When you talk about something like a sex crime that more often than not only involves two people, there's little to no physical evidence. And so your interview with that person is going to be very, very substantial to that case. And so if you're only allowed to go in and ask the person if they did it and then have to leave when they say, no, I didn't, you've handcuffed the ability to gain justice for that person who was victimized. That type of crime in particular, like I said, limits the other things that you can do as far as your investigation is concerned, because there typically is not evidence.
So, and is it any different as far as ages that you are interviewing using these practices, under 22, for instance, versus older individuals? Does that modify or change the approach?
I mean, you certainly have to be cognizant of the age of somebody and whether or not they are, if they do end up confessing, whether it's a knowing confession. I have had times where I've interviewed people and, we've kind of gone round and round about the same type of information. And they've said like, well, what do you want to know? I'll just tell you what you want to hear. And I'll have to tell them, I don't want to hear that. I want to hear what actually happened. So I can say that I've had that type of an interaction with somebody, but I don't think I've ever had a knowing false confession. More often than not, I have a pretty good understanding of what I believe has happened from the victim's statement or some other corroborating information. And so if somebody starts telling me that, information that has never happened, or I've never gained that information throughout the course of my investigation, then I would know that might be a false confession. I would be calling them out on that, saying, that's not something that I'm aware of. You certainly do have to take who you're talking to into account. A juvenile is going to have an advocate of some sort, either a non-involved party or a parent or even an attorney in the room. We're not going to have a custodial interrogation or interview with somebody without some sort of representation. That 18 to 22, again, these people are old enough to vote and make decisions like driving and all kinds of other things. I don't see an issue with having conversations with them about criminal activity that they may or may not have been involved in. Also, using deception, sometimes can rule people out just as easily as it rules people in. If you were to say something, like the DNA example, and they know for a fact that their DNA isn't there because they didn't do it, they're going to tell you that. Or if you were to deceptively make up a scenario and they agree to it, but that it's patently false because you just made it up on the spot, then that has to go in your report, and you need to be noting that for the attorneys, and they need to be making the decision to know that was not a knowing confession.
Okay, Karen, and then Angela.
Yes, thank you for being here and sharing this. I'm just trying to confirm and make sure I'm understanding this. So my understanding is that your perspective is opposing the bill. That I'm hearing that this would kind of make work less effective for police. Is that what I'm hearing?
Yes, ma'am.
Okay,
it would certainly make our job more difficult.
So I'm trying to understand, because what I'm hearing, my understanding of the bill here is that it's just saying you can't be deceptive in working with interrogating juveniles. I feel like we also heard that usually there's other evidence that could let somebody know if they are guilty or not. And then the other piece is that there's a large number of folks that could admit to doing something and it's a false admission. And so to me, this makes sense. I also see that there is the test of if somebody was to, falsely admit something, that they could follow this test and it could still count. But I'm just trying to see how it gets in the way for law enforcement. It seems like there's a path forward to get through if this person really did do it, but we're trying to protect folks who might be fall through the cracks.
So I'll answer as many pieces of that as I can remember, then I may ask you to repeat some
Yeah,
of it.
sorry.
That's okay. So, certainly there are times where people do fall through the cracks, and that's why there's, shows on Netflix and, podcasts and whatnot about those specific instances that happen nationwide. Those things do happen. Those things have happened over the course of time. Some of the custodial interrogations that you guys have heard testimony about happened when times were very, very different. And so not being able to be deceptive as a part of our interview with somebody, it's just another piece of taking away an ability that we have right now that is very effective. Being deceptive is not what I think most people think of. Being deceptive is as simple as being nice to somebody while you're talking to them. I've sat across the table from people who we have on video drugging and raping a 5-year-old boy, and I have to pretend to understand and empathize with that person to have that conversation with him to attempt to get the details of why he did what he did from him. That's a form of deception. I have absolutely no desire to empathize with somebody like that. But in order to,
I want to clarify on that.
Yeah, if you could really look at what the definition that we have of deception, what you just described doesn't fall within that. And also even, I would say, your earlier hypothetical that you say, if you said to a witness that, if we have a sample from the rape scene, would you expect to see your DNA there? That may not even fall within our definition of deception because of the way it was set up. So,
and I think that's part of the issue, part of the slippery slope is that deception is not well defined. And how do you define deception? And me saying that I'm having a great day today when I'm not, is that a form of deception? Some of the things that I've heard others give testimony about are coercion, which is definitely different. And the courts look at coercion differently than deceptive behaviors. Coercion, talking about withholding medication and water from people, that's a coercive tactic that would, in my mind, not meet the Supreme Court's ruling of shock to the conscience. If somebody's asking for food or medical or medicinal things, like you can't deny that of a person. Certainly in Vermont, the policies of the state police, if somebody's in our custody and they're asking to go to the hospital, whether we believe they're injured or not, we still have to take them. So if somebody is in an interview with us and they're asking to leave, the courts have already established that that's them being done with the conversation. So to define those two things, the coercion, the coerciveness of a certain interview, which admittedly read technique is a coercive interview tactic. And like you've heard from other people, it's being phased out or has been phased out because they don't like it. It's too aggressive, to be perfectly honest. And there's really no need for aggression when you're talking to somebody. Deception is different. Deception is implanting in their mind a possibility and leading them to believe that you know more about this incident or this crime than they think that you know.
I apologize. It's just that I want to make sure that we're getting your viewpoint based on what definitely is in the bill, because even just what you're talking about, yes, you're right. Deception as you're defining it is much broader, but I'm just a question if you have that language in front of you, or if I should just read it to you, because I want to make sure that we're tracking on this, because what we have for the definition of deception is that it includes the knowing communication of false facts about evidence. I suppose if you say, if we had this sample, would your DNA be there? I'm not sure whether that necessarily falls in that. Maybe we need to be clear. The knowing misrepresentation of the accuracy of the facts, the knowing misrepresentation of the law, or the knowing communication of unauthorized statements regarding leniency. Yeah, it's your example there may fit into that, but it's not entirely clear to me.
Sure. Another example of that would be, multiple suspects are taken into custody and you're interviewing one and you say that your two buddies down the hall are spilling the beans right now, and now's your opportunity. I mean, that would be a form of deception that I think would fit with this bill. That you're not shocking the conscience. You're simply stating the facts that his two co-conspirators could be spilling everything right now and giving this person the opportunity. The minimization of saying that a crime is not as big a deal as they might think, and that's a form of deception, I suppose. At the end of the day, that type of those issues can really only be dealt with by a state's attorney who's making any kind of deal or whatnot. We're the objective fact finders in the criminal case, and so our job is to gather as much facts and information and then turn it over to a prosecutor who assesses guilt or innocence. We don't necessarily have anything to do with that. We may find enough information to lead a reasonable person to believe that somebody's guilty, but at the end of the day, that's up to a jury.
All right, so I appreciate it. Back to you, Karen. I apologize for jumping in, and then Angela.
No, I think that covers it and is helpful. I just feel like it is, from my perspective, it seems like this creates a pathway to move forward. So I am wondering if the definition of clarifying that would be helpful. And I feel like the other piece that this points out to me is, like, if this was implemented, the training would be a really important piece of what is considered deception and what isn't, because it seems like that could be a murky area.
I would agree that that's definitely a murky area, and certainly training around it would be helpful if it goes that way. But along those same lines, you're still going to have people who have been doing this for X number of years. And so, to say that if they, were to use something that is now on the line or murky within the definition, and then to be, somebody, I forget which gentleman was talking about, then it becomes a, code of conduct violation and you can be fired. That's going to lead reasonable officers to not do interviews with people. And if that's the end goal, then great. I look at the end goal for what I do as, finding justice for victims. And being continually handcuffed, and my ability to do that is not an effective thing.
Angela?
Thank you for being here. I am wondering, you mentioned that deception has its place and it's a tool, another tool in the toolbox. Would you characterize it as a go-to tool in your interview practices?
No, I think an interview is really a case-by-case dependent thing. You can have interviews that are 5 minutes long. You can have interviews that are hours long. Earlier there was some testimony about how long is too long? But I've had interviews where I've been having conversations with people for hours about their involvement of, within a crime. Where we've taken breaks, they've gone out and had a cigarette. They've still been in custody, but they're having water. We're coming back. We're going over things again. So to say that deception is the go-to, I don't think is an accurate statement. It is sometimes applicable to a conversation where you have somebody who they continue to talk to you, but they don't. They realize the gravity of the situation that they're in, and they don't quite want to tell you what their role is, unless they believe that their involvement. And so if you use deception to kind of bolster what you believe you have for evidence, there are times where that's what will help push somebody over the edge to start talking about what their involvement was. And sometimes it just plain doesn't work. I mean, I had an interview in this very room a couple weeks ago that lasted only a couple minutes because the person was read their Miranda rights and they said, no, I don't want to talk to you. And that was the end of the interview.
So if it's not a go-to tool, are you, I still hear concern that if that tool were no longer in the toolbox, do you worry that you wouldn't have, at that point, you wouldn't have all the tools you need to do your job?
That's correct. I would be very concerned that taking that tool away from law enforcement as a possibility is definitely limiting our ability to do our job effectively.
And so one more question. Do you have any thoughts on something that was shared with us earlier today, that the use of deception by law enforcement has a detrimental impact on public perception of law enforcement?
I think, again, that's a case-by-case basis. When you have, the gentleman that was talking gave the example of fingerprints on a gun, but the gun doesn't exist, and that undermines the authority of law enforcement later on. I think that is a possibility. At the end of the day, that's up to the individual who is involved in that particular incident. I think knowing that we are lawfully allowed to use deception to talk to people, to use that in our investigations to gain more information, I don't think undermines our authority, but certainly there are people that do.
And then just one more, do you have any confidence that you would be able to find other tools? Is it possible that you relied on deception because you're allowed to, and then if it's not something you're allowed to do anymore, that you would find other useful tools to do your job?
At this particular moment, I cannot think of other interview techniques that are as effective as somebody else's own mind. So, no, I don't believe that we would, unless somebody comes up with a better way to speak to people, or make it illegal to lie to police. But I don't think that's going to happen.
Tom, then Barbara, then Joe.
Hello, Detective. A couple questions.
Yes, sir.
In your experience, when you're interviewing someone, it's important to develop a rapport, correct?
Yes, it is. Very important.
Is it also important to continue that rapport?
Yes.
What are the dangers if you get too coercive or abrasive, deceptive? What can happen?
So certainly if you are too abrasive, too aggressive, if you come out of the gate too harsh, people just won't talk to you. They'll shut down, and they'll invoke the right to an attorney, or they'll just say, you know what, I don't like being spoken to like that, which is why, for the most part, we don't talk to people, at least of the detectives that I am aware of and work with. We don't talk to people aggressively like that because it's not effective. People shut down.
Okay, I guess that's kind of what I was looking for. Also, do you think the age limit is too broad, or should it be a little more restricted, say to 18 years old?
In my personal opinion, would be not to restrict anything at all for age within the bounds of what's acceptable from the Vermont and the U.S. Supreme Courts. I can understand that somebody may not agree with talking to a juvenile under the age of 18 and using a deceptive tactic with them. I think on a case-by-case basis, there needs to be some flexibility with that, because there are cases where using a deceptive tactic or using deception during a conversation with somebody under 18 could be very effective in gathering information on the case to hold them accountable or to rule them out just as much as to rule them in. Deception is not a one-way street. So again, that's my personal opinion. I know that others would say that, the age limit of 18 to 22 shouldn't be applicable.
Thank you very much.
Barbara, then Joe.
So it would be helpful to hear what specific questions, like when you were just giving an example about the person who only wanted to talk a minute, but like what specific questions would be off limits to you? Like a vivid example of why you think we need to heed what you're saying. I'm still missing enough sort of granular detail. So I don't know if you can give us a couple of scenarios of like, in this interview, we did this and this is what happened and we wouldn't be able to do that anymore.
Sure. So my example of asking about DNA and the possibility of DNA, I've used that several times effectively, where...
I'm sorry, so you're saying you ask, you fade out a tiny bit. You ask if they know you found their DNA?
So the deception would be more so that, I may be interviewing somebody who has denied involvement in a sex offense case. And so like off the top of my head, I've used this tactic several times where they've denied involvement at all. And, in a case, especially a case that could be a couple of years old where the victim didn't come forward initially. And so there is no physical evidence. There is no text messages. The only witnesses are the two people that were involved. One of what would be a deceptive technique would be that I've said to them, hey, listen, this came forward today, but this incident said to happen, 2 years ago, and at the time, the girl went to the doctor and they took swabs of the inside of her body, and those swabs have sat on a shelf for the last 2 years. Now that we know that this case is going to come around, we're going to send those to the lab. Is there any chance that your DNA is going to be on those swabs? And leave it at that. I mean, that's as much of a conversation of using that as I would go with it, and let their minds kind of run with it. Somebody that has no involvement is still going to say, no, it's not.
So the deception in that case is that the person had gone and gotten a rape exam and had a rape kit.
The deception
when they may not have. Is that right?
The entirety of that. I mean, it's correct. The deception is that there is evidence that doesn't actually exist, that there's evidence that we're going to process and send to a lab that we're not going to, and that person at the time went and saw a doctor. I mean, just her seeing a doctor in that scenario, that would be evidence in and of itself. We could get a record of that. But if that never happens, that's another deception. And so, to be able to use a tactic like that opens up the potential that this person admits to behavior, or even if they don't admit to it, they make, minor admissions of like, oh, well, we did do that. I was involved in that, but it was consensual. And so, now when I present that case to a state's attorney, it went from, the person's initial statement to me went from, I was never there, it never happened, to, okay, well, I was there and it was consensual. And then our victim, who then has to get on the stand and testify, says, no, it was not consensual. That's an example of using that type of a deception.
That's great. I appreciate that. I don't know if you have any other ones that come to mind that would be helpful.
Off the top of my head, make some notes. Minimization, which is another form of deception. We certainly use that a lot. I know people don't like that as much because it does fall back to the read technique. But using minimization to talk to somebody about, and I talk about sexual abuse crimes because, again, I've done a lot of it for the last 8+ years. But these are some of the hardest cases where your interviews, in my opinion, are paramount. In cases where there's a ton of evidence, even if somebody is in custody, you walk in the room and they don't want to talk to you, there's still there's still all this evidence. When you don't have the evidence, that's when you need to be able to speak to people and talk to them and hear from their perspective what happened. And so, minimizing deceptive tactic would be, saying that like, hey, listen, I understand that this happened, and there are things that you can't control about your body, and it's difficult to have that to tell that 5-year-old, no, don't touch my body, but it's okay because like it wasn't your fault. Saying things like that to try to get to build the rapport with that person and minimize in their mind what they've done as being so horrible, and moving it down the chain of like, okay, this isn't that bad. I'll talk about this small thing. And then once somebody starts to talk about, that minor thing that they believe is minor, the minimized offense, and then they start to the waterfall starts to flow, and they begin to talk about the other things that they've done. That will be another deceptive tactic.
Thank you.
Joe.
Thank you, Detective. Having police officers in my family, it's been my observation that they are some of the keenest observers of human behavior because of just all the years spent in observing and in working with people and trying to understand what's going on. And so, my question for you is, do you agree that people have a desire to conform to authority, that people have a desire to do what they're told in stressful situations generally?
Again, that would be a case by case basis. There are certainly people who can conform. And I mean, like, you can use an example of if you have a child and you're talking to your child about taking a cookie from a cookie jar, and that there are crumbs on the table, and that when you ask them if they took a cookie and they say no, that they're lying because their facial expressions, and you can certainly get them to admit to taking a cookie just by pointing these things out to them. There are certainly people that are going to tell you whatever you tell them that you want to hear. And then there are people that are, no matter what, they're not going to tell you, no matter how much evidence you throw at them. And then there are people in between that, they know that they've done something wrong. They don't particularly want to admit to it because self-preservation. But once they know that and you've treated them decently, maybe you've had to use some deceptive tactics to get them to speak a little bit more about what they've done, then they will talk to you. Certainly there are cases nationally where law enforcement has gone in and gotten somebody to confess to something that they didn't do, using coercive tactics, and that's unfortunate that that's happened, and that hopefully that doesn't happen anymore, but unfortunately I'm sure it will. But that also needs to be looked at by the rest of the judicial system, the prosecutors and the court, to say, did this person knowingly offer up this confession? Did they just repeat back what the officer wanted them to repeat, or did they actually explain what happened? And then from the officer's investigation, there is corroborating information to substantiate what they have said. So an investigation is not and cannot be as simple as a confession from one person.
And thank you for that. Do you think, based on that children are more likely to want to conform with what an adult or authority figure is telling them versus an adult?
Every child is different. Age, backgrounds, intellect, all those things are going to come into play. And so there are certainly some very, very streetwise kids that would go up against adults all day when talking to law enforcement. And then there are some kids that, you would just have to kind of look at them funny and they would confess to doing anything. And that's, certainly that wouldn't be what we would want or hope to get out of an interview with somebody. False confessions are not good for a lot of reasons. and they're certainly not good for us. They're not good for investigations. They're not good for the person that makes them. At the end of the day, if we get a false confession that we can't corroborate, and then that person is somehow goes through the judicial system and goes to jail, that's not okay. That's not a win for anybody. And so if we do talk to a child or talk to a younger individual who confesses to something and we don't corroborate it, then we haven't done our job either.
Thank you.
Tom?
We just brought up corroborating confessions. Is that a normal process when you get a confession from somebody? And I'm going to assume sometimes you're gonna know if it's a false confession. But I guess maybe you could just go through the steps a little bit on how you would do a back check on that.
Sure. With interviews, no matter what technique you use or what training you've gone to, there isn't always this is what you're going to do every single time exactly this way type of way to put it. Everybody's different, everything's different. And so when I or any of the detectives that I've worked with or been trained by do get a confession out of somebody, we're going to circle back around and we're going to have them, now that they've admitted, okay, I did it, this is what I did, we're going to go through it. We're going to, from start to finish, okay, well, tell us where, when, how, who did you talk to about this? Who did you tell? What did you do after? And so gathering as much detail from that person as we can so that we can, if we don't know about something already, we can go out and get that information. If there was somebody that they talked to after the crime, we're going to go find that person and interview them. If they're telling us everything that we already know, that only the victim would know, or we would know from our investigation, that goes to substantiate what they've told us as well. But if they're telling us things that have nothing to do with the crime that we're investigating, then that just goes to show that maybe they're not being as truthful as we thought they were. And that all is recorded, audio, at least audio. We all use digital recorders, but typically if it's a custodial interview, it's going to be audio and video recorded. And then we're going to pass that along to the state's attorneys, also in a written document that details, these are the things that I was told, and these are contrary to what we know from the investigation.
And earlier you were talking about some deception that you use, and you were talking about sexual assault and rape cases. So it went through my mind, if you weren't able to use deception in say, a rape case, it's not even really a question, more of a statement, that potentially rapists could go free and victims would get no closure on this. Because I got to believe that at some point in some cases, you're going to get the information you need from somebody only with deception.
That's my personal opinion, yes. That there are certain cases that without the ability to use deceptive tactics and speak deceptively, we will not get closure in those cases.
And have you had any of these types of cases where you use deception on somebody in the age range that we're talking now, up to the 22-year-old age range, where the deception has gotten you the information you needed to prosecute, I guess, an important case, or like a rape case or sexual assault?
There certainly throughout the years, that age range has come up, especially in the SIU cases. You get a lot of teenagers that, everything is good in the moment, and then the consent piece changes, and so they don't want to, partake anymore, and then it becomes a he said, she said type of an investigation. So using deception to gain more information has certainly happened in cases that I've worked on.
And just one more thing, and it may have been said before I came in, is again, how many years have you been doing this?
I'll have 14 years in July.
And I'm just wondering, in those 14 years, has there ever been a case where you used deception, got a false confession, and the person was convicted?
Not to my knowledge, no.
You good? Joe?
Hi, so another question, sorry, Detective. One thing, so imagine that you have a case, and I'm sure you don't have to imagine this, because I imagine it must have happened to you, where you have several suspects. You're not quite sure which suspect is the suspect that is the one who did it, but you've narrowed it down to 2 or 3 people. Would a confession by one of those people make you more likely to focus on that person as the main suspect over the other suspects?
I think if it's a scenario like that where we've narrowed it down to a couple of people, the totality of the circumstance is going to kind of dictate the investigation. So just because one person confesses and the others don't, doesn't mean that the others still weren't involved to the same level. At that point, I don't know that we would have custodial interviews into those people. If we're still investigating this and we're still developing leads and developing suspects, I don't know that we'd be taking people into custody to bring them back to our barracks. I'm not saying that you couldn't, or there wouldn't be a scenario where that wouldn't happen. But just because somebody confessed, again, doesn't mean that our job stops. We still need to vet that information. So if we did have somebody confess and there were 2 other people, that may be something that we use with the other 2 people to say, listen, your buddy down the hall just gave it all up. Now's your chance. Which is a truthful statement in that scenario, but can also be used as a deceptive tactic in another scenario.
Yeah, thank you.
Any other questions for the detectives? I think we're good at this point. Thank you so much for your testimony. It's been very helpful and very illuminating.
Thank you very much, everybody.
So we will move on to Tucker Jones. You can identify yourself for the record and proceed. I appreciate you being here.
Yeah, of course. Good afternoon, Chair Lalonde, and hello, representatives. My name's Tucker Jones. I'm an attorney at the Department of Public Safety. The department is concerned about this bill in its current form, but we do see a path to get to yes on it. As you heard from Drew Coda, the department is really concerned that the bill can interfere with legitimate investigations into serious felonies by limiting the use of targeted deception under the definition in this bill of knowing communication of false facts about evidence. Our primary recommendation on this bill is to change the age threshold on the prohibition on the use of deception from age 22 to age 18. To my knowledge, this is the age threshold chosen by every other state that has passed similar legislation. So this would include Utah, House Bill 171 with an age threshold of 18, Delaware House Bill 419 with an age threshold of 18, Illinois Public Act 102-0101 with an age threshold of 18, and Oregon Senate Bill 418 with an age threshold of 18. My understanding is that Indiana Senate Bill 415 with a third reading yesterday, which passed, also has an age threshold of 18. California's age threshold in Assembly Bill 2644 is actually 17. The department does have several additional recommendations on this bill relating to the judicial standard to evaluate the use of deception, as well as the provisions for creating a statewide policy. I'll briefly give a little background and go over these recommendations and why I am making them. And of course, if committee members are interested in any of the specific language I'm referencing or mention, I can provide that to you. And I'm always happy to talk with legislative counsel and others offline on the provisions that I am discussing. So the voluntariness standard has already been discussed this morning. The prosecution must prove that a statement is voluntary by a preponderance of evidence if the defendant raises it with the judge before trial in a motion to suppress. The jury then determines the voluntariness of a statement at trial beyond a reasonable doubt. A statement is voluntary, as we heard earlier, if the coercive governmental conduct played a significant role in inducing the statement. And some of the relevant factors in that voluntariness analysis include the youth of the accused, his or her level of education, and his or her level of intelligence. So this is under the current constitutional standard of voluntariness. Under this current standard, providing a suspect with false information, absent additional coercion, may, but is not always sufficient to overcome a suspect's will and render the suspect's statement involuntary. As the courts describe it, lies about incriminating evidence taken alone are not enough to make a resulting confession involuntary. And as we heard earlier, courts distinguish between lies about the evidence of the case itself and any threats, improper influence, or physical or psychological pressure. There's a distinction there, and it's a distinction that's relevant to kind of our specific conversation on deception. Lies, the logic that the court has explained to support this distinction is that lies about evidence of the charge are more likely to evoke, if any feelings at all, a suspect's belief about his or her own culpability. So in addition to that existing voluntariness standard, we also have a common law standard called corpus delicti. It's a legal principle which mandates that where the state's case is based on a confession, the evidence of the crime must be corroborated by independent evidence. And so that's a legal principle that is occasionally litigated, and it is also a principle that is codified in our juvenile statutes in Title 33. And that's in 33 VSA 5228, which reads that a confession out of court is insufficient to support an adjudication of delinquency unless corroborated in whole or in part by other substantial evidence. So that's another aspect of existing law that relates to this topic of the use of deception generally. And in addition, I don't think this has been mentioned yet in this committee, so I wanted to reference it. In 1982, the Vermont Supreme Court ruled in re ETC that a juvenile specifically may waive his or her right against self-incrimination and his or her right to counsel under the Vermont Constitution only if he or she is given the opportunity to consult with an adult, and that adult is one who is not only genuinely interested in the welfare of the juvenile, but completely independent from and disassociated from the prosecution. Such right accrues to a person under the age of 18, and it is triggered at the commencement of a custodial interrogation by the police. So that is part of the existing legal framework before this bill that exists right now to take into account some of the policy interests that we are discussing. I want to just give now just a brief overview of this concept of deception as used by law enforcement. So in general, law enforcement uses deception throughout the investigative stage in the criminal process because people who commit crimes tend not want to admit to or get caught for their behavior. So for this reason, law enforcement is tasked with what's been described by the courts as a competitive enterprise of ferreting out crime. And it's distinct from the criminal process that follows once sufficient evidence is developed. Once the crime has been ferreted out by law enforcement, the rest of the judicial system processes that information and presents it to the relevant people to adjudicate the particular case. The common areas of deception used by law enforcement include the use of wiretaps, informants, sting operations, and undercover operations. So it's not just in the custodial interrogation context in which deception is used by law enforcement during the investigative stage. During the interviews of suspects, targeted deception is used by officers in Vermont, not all officers, but some and many, to elicit truthful statements by suspects, including suspects in the 18 to 22 age range, particularly in serious felony cases, including murder and sexual assault. So during interviews of suspects, the logic is that few suspects offer up a full statement of their involvement in criminal activity. And this is particularly problematic, as Detective Sergeant Coda was getting at, in some of the most heinous crimes, such as child sexual abuse, which may involve no physical evidence at all and no witnesses other than perhaps a child who may not be able to adequately testify due to their age. So a specific Vermont example on the use of deception in this context is State v. Colts. So this is a 2018 case, 2018 VT 131, in which an adult defendant confessed to, I believe, aggravated sexual assault of his 11-year-old niece. The detective in that case, and if you don't mind, I'll just give you a little description of the circumstances of that case, because I think it helps flush out some of the circumstances that Detective Coda was just describing. And it's a worthwhile case if you're interested to read to understand how it played out in that particular scenario. So the detective in that case told the defendant that she had physical evidence to support the juvenile's allegations. The defendant asked whether this meant that there was DNA evidence, to which the detective responded, yeah. What's the explanation? How did your DNA, your transfer of body fluids or cells or hairs, get on the juvenile and into the juvenile? How did that happen? The police did not have any such evidence. There was a back and forth with the suspect, and then the defendant replied nervously, yeah, I'm going to jail. There was some further back and forth, and the defendant confessed that he had repeatedly had sexual encounters with the juvenile in greater detail, and lamented that he should have anticipated that the juvenile would eventually tell a friend what he had done, leading to his apprehension by the police. So this scenario was challenged on voluntariness grounds, among others. And here, the court said that the defendant confessed in response to the detective's claim that there was DNA evidence to prove his guilt. But the detective's false claim, and this is the court's explanation, is not enough to render his confession involuntary without other coercive actions, such as promises of leniency. But the detective here made no promises of leniency. Lies about evidence of the charge, and this is the quote that I was reading earlier about the court's explanation for why it makes this distinction about deception. Lies about evidence of the charge are more likely to evoke, if any feelings at all, a suspect's beliefs about his or her own culpability. So that's a case in which that played out. Now, I assume the defendant was not in the 18 to 22 age range in that particular case. I believe at the time of the particular conversation, he may not have been in the custody of the detective, but I use that case as an example of the technique under those particular circumstances of using deception as would be defined in this bill. In this scenario, in the scenarios that Detective Coda was describing in this particular case, we're not talking about a 7-hour interrogation. We are not talking about the suspect getting to say, I did it, and then closing the file. We're really talking about the use of targeted deception to elicit truthful statements that are corroborated by the complaining witness and other evidence. So Drew Coda gave the example of the SANE kit, and there was also reference to the other example in which there are multiple co-defendants, potentially in not a sexual violence context, but in a physical violence context, or in a drug trafficking context with firearms. that this is the other area that there's concern about the use of deception and how it would be affected by this bill. The co-defendant example was one that was just brought up. The officer says, your co-defendants have decided to talk to us. Would you like to give us your side of the story? That may be a technique that's used even when the co-defendant is not talking. That is the extent of the deception. There is nothing further than that. There is no planting of ideas about what happened and trying to get them to agree to it. But it would constitute deception under the definition in this bill. So all of these are examples of deception. They are used to elicit a suspect's true reaction about his or her own culpability. And it is never, I did it. It is always more. It is always, give me the details of what really happened. And it's the details that are corroborated, like in State v. Colts, by the evidence and by the complaining witnesses' statements. But anyway, that's the context of the concern here about the legitimate use of targeted deception. Now, there was also...
So before you move ahead, I apologize, Angela, before you move on from that, go ahead, Angela.
Thank you. I have a question about that point you just raised specifically. Is it your feeling or opinion that the use of targeted deception is not covered in this law, page 6, section 3, subsection B, again, any actions of a law enforcement officer or government agent in violation of subsection A did not undermine the reliability of the person's admission, confession, or statement. So that we were told earlier today that this section actually codifies what I believe you were just describing, the practice that is typically used currently, that courts will allow a confession, will allow this sort of, to use your words, the targeted deception, provided that targeted deception didn't undermine the reliability of the confession. So I read that and think that what you're describing will still be permitted.
Potentially, and I have some comments on the specific factors there in subsection A and B. And if it's, I can get into that now, but I perhaps was just going to give you some explanation of why 18 and then the specific test and my concerns about the test as written. I think we can get to a place where that test makes sense, but I have concerns about its practical application now. And so just specifically, subsection A and B, there's 2 factors in each one. So we have voluntariness, we have induction by law enforcement, we have undermining the reliability, and we have did not create a substantial risk. And so right now, under this test, those 4 factors all have to be proven by clear and convincing evidence. And I'm worried that as a practical matter, courts will have a difficult time making that determination. And that is in part based on my review of the other legal standards that other courts have adopted, which appear to be much more pragmatic and straightforward. And so one of my recommendations is that if the committee pursues this, that they consider a more streamlined standard that focuses on reliability and actually focuses on that second prong, if that is the wish of the committee. But one of the observations I would make in reviewing the legal standards in other cases, in other states for this similar type of bill, is the matchup between preponderance of evidence and clear and convincing evidence with what the factors are that have to be proven by that burden. So my understanding is that I think it's the only state that has a clear and convincing evidence standard. I believe it's Oregon, has a clear and convincing evidence standard for voluntariness, which, if you think about it, makes sense because the current standard for voluntariness at the trial court, at the judge level, is preponderance. So it's heightened for the sub-18 category, and that makes sense. Now, I am not aware of any state that has a clear and convincing evidence standard as to reliability. I believe Delaware has a preponderance standard for the reliability, basically that second prong in the subsection B standard. So that's kind of the extent of it. I have some specific language that I would recommend considering. I would also recommend comparing it to these other states to see how it stacks up. But I do have a concern about the court's ability to really make findings, clear and convincing evidence for all of those facts. In practice, I want the court to be able to make this determination based on three things. One is the video or audio recording of the interview itself and any statements by the officer in a motion to suppress hearing and the suspect in a motion to suppress hearing. If it's a clear and convincing evidence standard for some of these other factors that, are not currently used as standards, like the reliability and did not create a substantial risk, I'm worried that the court will not be able to make a practical judgment call based on those three pieces of evidence in a motion to suppress hearing. That's open for dialogue and discussion, but in my review of the other states, legal standards or judicial standards for reviewing these confessions, I think my proposal would make sense. If the committee is really committed to a clear and convincing standard generally, I would consider looking at the Oregon standard, which is clear and convincing for voluntariness, versus the Delaware standard, which is preponderance for reliability. So something for continued dialogue and conversation about, perhaps. I'll just speak briefly to the rationale for the age 18. We do recommend the age threshold just track every other state that has adopted a similar law. The age range of 18 to 22 does affect real cases with real victims. And we are concerned that experimenting with a new legal standard, especially a heightened clear and convincing standard, will potentially exclude truthful statements from real cases that shouldn't be excluded. That's the concern. By way of some empirical support for the age threshold of 18, in a study of the data by the National Registry of Exonerations, which is a link I can send to you, cited by the Innocence Project on its website, it found that the proportion of exonerated defendants who confessed were disproportionately under age 18 at the time of the offense. This is some of the things that Marshal Paul was talking about during his testimony. However, it also found that the proportion of those exonerated defendants over 18 who confessed were the same as, actually 2% below, the proportion of all cases of exonerated defendants who confessed generally. So in other words, in that particular review of 2,400 cases, the age threshold of a greater likelihood of a false confession was below age 18. So this is some empirical support for the idea that 18 as an age threshold, tracking every other state, would be an appropriate choice. So that's the department's position, that the age threshold be 18 and track the other states. And basically you'd have this alternative legal standard for sub 18, and then your standard voluntariness analysis for over 18. I just have if you don't mind, I just have a few more comments, Mr. Chair.
Yeah, Joe, did I miss you? Did you have a question? I
Yeah,
apologize.
what was the name of the case again? You give the quote, likely to evoke a suspect's feelings of culpability, I think you said. What was the name of that case?
Yeah, so that's State v. Colts, Kolts, and it's 2018 VT 131.
2018 VT 131. Great.
And as it turns out, the investigating detective from that case is Detective Ruth Whitney, who unfortunately had technical difficulties this morning, but she may be able to join you at another time and can just talk about her experience with that and other scenarios.
A couple more questions. You're talking about 18 Have you thought at all about the impact of these techniques on those with developmental or other disabilities that give them cognitive impairments? So what about those folks?
Yeah, so it's a good question. Someone's cognitive capacity, someone's intelligence is a factor in the voluntariness analysis under existing constitutional law. So it is something that the court would take into account after the fact in evaluating whether an individual's will was overborne. But as it relates to this particular sub-18 prohibition on deception, I haven't seen it in any of the other state legislation as its own category. And there was some discussion this morning about the problem with that, of having the officer essentially attempting to make a determination of whether someone met the criteria for that at the time of the interview. As a factor in the voluntariness analysis after the fact that the court does, that makes sense. And that is in fact a consideration. But I have not seen it come up in this type of attempt at prohibition on the use of deception.
Great. Is an attorney allowed to make a statement of material fact that is incorrect to a third party involved in the case?
No, right. So Julio Thompson was discussing this morning an attorney's obligations and, of course, judges' obligations once a case gets to the courtroom. And I alluded to it earlier, but there's a really important distinction between the role of a law enforcement officer in the criminal justice system and a role of court personnel in adjudicating a case once it gets to court. So as I was saying earlier, deception is used as a matter of course in a variety of avenues in the investigation of crimes itself. And there's some of the reasons I was talking about, but really what it comes down to is that people don't want to admit that they engaged in criminal behavior. And so if an officer goes online as part of a sting operation to ferret out people who are trying to abuse children, and they pose as a 14-year-old online, they may be able to engage in conversation and dialogue with a perpetrator, a predator, and ultimately apprehend them. Now, if that officer represented himself as an officer online to that same predator, well, of course, you're never going to actually get any conversation with them, and they're going to have no interest in talking to you. And so that's an example outside of the interview context of why deception is used during the investigative stage by law enforcement officers. It of course has no place in the adjudication stage by any lawyers or judges because the crime has already been ferreted out. And so there was no competitive enterprise at that point to ferret out what happened. It is just a question of presenting the evidence that was collected during the investigation.
So it's clearly not okay, obviously, as you just said, to do that in court, make a false representation. And you just gave some pretty compelling reasons why a law enforcement officer may need to be deceptive, such as doing a sting operation or wearing a wire or something like that. But why is deception necessary in a custodial investigation, which is what this bill covers?
Yeah, a custodial interview.
Excuse me.
Specifically. Well, it's the same principles apply, but the constitutional safeguards are different. So in the other areas of in investigative stages, the kind of legal principle that limits investigative techniques is entrapment. And in the custodial interview context, it's voluntariness currently. But the reason, to answer your question, the reason that it's used is for all the reasons that we've just discussed. The individual who is in the custodial interview is inclined not to admit that they engaged in this particular conduct. And if they're confronted with potential evidence of their own guilt, they may be more inclined to actually discuss what actually happened. It's the same with rapport building. Rapport building, there is some concern that we have that some rapport building could bleed into the misrepresentation of the facts, the second prong in the definition of deception. And rapport building is used for the same reason. That, of course, if the officer went into the custodial interview and said, "You're accused of this heinous crime, and it's just absolutely horrible what you have been alleged to do," well, the individual is likely not to discuss the circumstances of the incident with them. But if they say, "Yeah, things happen. I understand. Why don't you just tell us what happened?" You're perhaps going to get a different response. That's the logic. I don't know. Was that specific enough for you?
Yeah, no. That which leads to my next question. I mean, do you agree that these techniques have led to false confessions?
Well, in the work that the Innocence Project is doing, of course, they are making that specific connection. I think they were talking about 30% of the 30% of the exonerations involved, at least in part, a false confession. Now, the circumstances that resulted in the false confession may have involved deception, but it also may have been involved 7 hours of interrogation of a 15-year-old in totally inappropriate circumstances in which they were denied access to their parent and told that they had done it and were repeatedly fed the information to regurgitate back to the detective. And that's different. That's different than deception. That's really coercive behavior. And it may have resulted in a false confession, but it wasn't a result of someone saying, a St. Kit was done that night. Is there any concern that, in a 5-minute custodial interview? That's a totally different circumstance. So false confessions are absolutely, we have the stats, the Innocence Project has their stats on it, but it's really not, the Central Park 5 is not how Vermont law enforcement conducts custodial interviews. I've spoken with 5 detectives at this point who've on this subject, and this idea of multi-hour interrogations of juveniles is not something that happens that I'm aware of.
Do you agree that juries overly rely on confessions in their considerations?
And that is one of the other concerns I heard raised this morning, what the power of the confession. And so that's, of course, a concern that needs to be taken into account. One of the helpful things to keep in mind is that not only under the current voluntariness standard does it need to be proven by a preponderance of evidence to the judge that it was voluntary, but an instruction to the jury can also be requested to ensure that the voluntariness of the statement is proven beyond a reasonable doubt at trial. But I'm not minimizing any of the points you're raising, Representative. I recognize them as as legitimate as discussed by the other witnesses. We're not asking for a wholesale request to abandon this bill. 5, 6 other states have done something similar. We just want to make it somewhat consistent with those other states.
Okay, thank you.
So I have a question as well, and then there may be some other questions. So you mentioned targeted deception, and I'm wondering if the target should be different than 18 and under. Could the target be child sexual assault cases or the special investigation unit, rather than doing the age, but doing the type of crime that's being investigated that without this interrogation or interview technique, law enforcement is really at a disadvantage? I wonder if you comment on that concept, and instead of your construct of looking at the age as opposed to what kind of crime is being investigated.
It's a great question, and it's one that I've considered. I drafted up. All right, well, if you're doing 6 crimes, what are the Title 13 offenses? What are the chapters basically that we'd include in that? And so I did that, and then I got feedback on, well, all right, well, what about the serious violence? What about murder, aggravated assault? And so it's like, okay, well, you add that in, and then the other category, the other bucket, is certain drug trafficking crimes, especially drug trafficking with firearms, where you have some very sophisticated individuals who may be actually quite young who are engaging in that behavior. So if you have those 3 buckets, in theory, you could start creating a list, Big 12 plus or what have you. But then it bleeds over into, well, are we really just talking about all felonies? And then the follow-up question to that is, well, are we excluding domestic assault, misdemeanor first offense domestic assault? And so I think you could try to create a list, but the problem becomes, you keep on finding these circumstances in which the targeted deception may be used in that circumstance. The primary concern here, the concern in all these other states, is the disproportionate effect, the disproportionate balance of false confessions in this sub-18 category. And so that was the logic that these other states adopted. I like that logic better because it doesn't require officers to be consulting a list of 5, 10, 30 offenses on, is this, and they might not know what the ultimate offense is at the beginning of their interview, custodial interview.
Well, how about if it was the SIUs who seem to focus on particular types of crimes, or or ICAC? ICAC, did I get that right?
Yeah, and that was the exercise I went through, but then this also pops up in other serious felony contexts. It pops up in the physical violence context. It can pop up in the drug trafficking context. And my concern is that it's not necessarily even limited to felonies necessarily. It could pop up in the domestic assault context. And so that's why the department's preference, after kind of going through that exercise, is if you're going to pick something, pick 18 and just have it as that being the trigger.
Yeah, no, I see, Ken. I'm just not sure I'm done with my question, because I'm still more troubled by going to 18 than trying to figure out a different carve out that's getting to some of these other crimes. And I've not heard the same concern, but we haven't had a bunch of testimony yet that there seemed to be a focus on the he said, she said kind of crime, which I don't think that's the drug crime, the murder, and there's no he said, she said there, presumably, because one of the people is no longer around. So I would like to explore that a little bit further, at least where I am right now. That is more of a possible way forward than dropping to 18. But that's just me. But I do want to keep that on the table as a possibility. And even in that particular situation, the other question I had, and I'll get to you in a second, Ken, is if we do something like that, and this may be more of a question for the state's attorney, is do we have some, presumably from what I heard from Detective Sergeant Coda, they'll do what they do, and then it's up to the state's attorney to decide if this is a confession that they can go ahead with as evidence. And you also mentioned the need for corroboration in 33 VSA 522A. If we are going to have a carve out, whether we should also make sure there's some requirements put on the state's attorney to make sure that any confession actually, meets the appropriate standard of voluntariness, et cetera, any of that. I don't know if you have a comment on that part of what I just suggested.
Well, there's, Drew Cota was referencing these thresholds that occur. And the first threshold is the case gets to the SAs and they decide whether or not to charge it at all. Or they can send it back and say, will you please go interview this person, or can you pursue this X, Y, and Z? So that's the first kind of discretionary decision-making from the judicial system. to determine whether to proceed with the case. I can't contemplate how, we'd put limitations on that discretionary charging decision, but what we definitely have is once it is charged, you have motions to suppress and dismiss for voluntariness. Now, under this bill, you'd have motions to suppress and dismiss for the use of deception if they meet the age threshold, but also you can have motions to suppress and dismiss for violating the doctrine of corpus delicti, where all you got is the confession. And so there's litigation about what meets the standard of corpus delicti. And I think it pops up in the motion to dismiss stage, or it has. So I think that's typically how it would play out.
Right. Okay. I appreciate it. Ken, go ahead.
So, hi, Tucker. Just for clarification, you are more comfortable, or one thing you'd like to see changed in this bill is the age to go back to 18 and older. Is that correct?
What we're recommending is that the current prohibition on the use of deception is 22, and we recommend that be lowered to 18 and below. So right now it's 22 and below, or below 22. Forgive me. But
I went through that same thing earlier.
But what our recommendation is to change the number.
Okay. Thank you.
Other questions for Tucker? Not seeing any right now. I'm sure but I'm sorry, you had a few more things you wanted to hit on. Go ahead.
Well, I apologize because I'm taking a lot of your time. So I'll just be very quick and I'll just flag these if you don't mind. As to the policy provisions, I just want to flag as a threshold issue, this bill out of Senate Judiciary, as was mentioned earlier, included an appropriation for a policy director at the Criminal Justice Council to develop this and other statewide policies. That appropriation has since been stripped from the bill, but the rest of the obligations of the bill are still there. My understanding is the appropriation was included because the council requested it because they believe they didn't have the capacity to develop the statewide policy themselves on top of all the other policy work that they have. So I know that Chris Burkell's here, so he can speak more to that, but we have concern because, as you know, the Department of Public Safety played a significant role in the development of the use of force policy. And to do it well is an enormous it takes an enormous amount of resources. And so if this is going to be a burden that's placed on the council, we want to ensure they have the resources to do it well. But I also just wanted to flag that, I'm not sure if this statewide policy idea is necessary. I've spoken, as I mentioned, to 5 detectives so far about this topic. I've heard no concerns about detectives basically engaging in improper interview techniques that come close to overbearing the will of suspects in this state. I've heard no concerns about long interrogations, let alone any of the more concerning coercive behavior that's already prohibited by the voluntariness standard. So I just want to flag that for you. If the committee pursues a statewide policy, I anticipate law enforcement leaders will seek inclusion of a diverse array of methods and tools based on their training and experience in the field. And so I'm concerned about the dialogue going to a uniform, single, exclusive method of interrogation, because my understanding is right now in Vermont, law enforcement officers use a variety of methods, and some are better fit for certain officer personalities and better fit for certain circumstances. Right now, the policy development provisions do not include any law enforcement subject matter experts who actually conduct these interviews and attend these trainings. So I do recommend that if you pursue a policy to include in the development stage, DPS, troopers, sheriffs, chiefs of police, and other law enforcement leaders in the state in the actual development of any policy itself. I would also flag the timing of the development of that policy in light of the fact that there's no one currently employed that is tasked with developing this policy and how long it takes to hire someone. I'm concerned about the ability to kind of create, adopt, and train under the timeline proposed in this bill. So it's just something I'm flagging. And, that's all I have. I really appreciate all of your time. We welcome the opportunity to collaborate on this bill. We have recommendations on how to improve it. I'm happy to provide any of the language I've discussed with Ledge Council and others if you'd like to discuss it further. And I just thank everyone in the committee for their time this afternoon. Thank you.
So I do have one more person has a question, but can you send through Panina, actually, you mentioned a number of recommendations, and it would be a lot easier if you actually sent us proposed language on those recommendations for us to take a look at. So if you could send that to Panina, that she can post it for us and we can look at it. Angela.
Yeah, thanks. One last question. You just brought my mind back to another really helpful document that was shared with us this morning, Reducing Risks, an Executive Guide to Effective Juvenile Interview and Interrogation from the International Association of Chiefs of Police. Are you familiar with that document or?
I'm so sorry. I don't have it. I haven't reviewed that yet.
Okay.
But well, I will.
Yeah, I was just curious why you think the Vermont Department of Public Safety and other maybe municipal police departments, other law enforcement agencies in Vermont might have what sounds like quite a different take on this than the International Association of Chiefs of Police.
Yeah, and I am sorry I can't comment specifically on the recommendations there. I will say one thing. The law enforcement. I've talked to 5 detectives so far on this subject. Everyone recognizes that the sub-18 crowd it has special provisions anyway, and there's special accommodation in that realm. So there's not for example, I'm not hearing a strong push on the absolute need for deception in the sub-18 realm in general from Vermont law enforcement. What I can report to you is that from who I've talked to so far, there's a diversity of methods and tools that are currently employed. Some law enforcement officers only use certain methods, and some law enforcement officers use a variety of methods. There are some law enforcement officers who exclusively use the peace method, and that works for them. And there are some that use bits and pieces, as Drew Cota was referencing, from different techniques. So that's kind of all I have to kind of characterize the state of the topic as I know it, which is relatively limited. I understand.
Thank you.
So I thank you very much, Tucker. I appreciate that. And let's take a 5-minute stretch break. I do want to get through the rest of these 4 witnesses that we have, and it may go a little longer than we normally are here. But I, since we have the folks here and we're all focused on this issue, I would like to get through those 4. But let's just take